Man up, slaves, and hit those buttons, or I'll send ice.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape ape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation, with gross castration, S.W.A.P, citations, by your intimation. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation, with gross castration, in skewed citations, by your intimations. I'm a truth in rotation, you're a cheap imitation. Dog said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna clank another hit of this good shit, and I'm already it, so take over, it's been non-big.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Greetings, everybody. Hope everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit those buttons, like, share, and subscribe. There's a PayPal link down in the details section for anybody who wants to share some love. Always appreciated. And let's get into it. For those that don't know, we're currently going through an eviction. And, of course, it's a wrongful eviction. And I am assured that we will win because we are right. We are correct. And it may take appeal and, of course, follow up with a civil rights claim. But tonight I'm going to go over some paperwork in preparation for yesterday's hearing, because I expected either an award to the property management for the eviction or a dismissal. And the judge instead took it under advisement for a week or so and will get back to us. So we're pending the decision from the magistrate, actually, not a judge, but a magistrate. And so I'm going to go over my preparation for emergency stay of execution, pending the appeal, and of course, issuing an appeal. So let me get into that. The StreamYard link is pinned for anybody that wants to join the panel. I am going to go over this paperwork first, and then I'll open the panel for anybody who wants to have discussion about it. And I would hope that people will hit that link, because this is something that is prevalent amongst the common people to be evicted. And I think many of them are wrongful. And I have information in my own case that would behoove you to do your research. Like I've said, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know, because this is the inherent part that most business people lack. They will go to an attorney rather than do the research and know themselves. And this is the pertinent point in our case. We have 3 points of discussion. And one is that the property manager admits that they've been doing property management for 8+ years, that they did not issue a notice, a 7-day notice to cure once we gave them a complaint about a noise issue. And they also did not know that they have a strict statutory duty to do so. And so we're going to go over this information. And of course, anybody that's taking notes, this is in the Iowa District Court of Black Hawk County against MGT Property Management, which is the plaintiff in this situation at the point, versus Keith Little and Joyce Schmidt, defendants. The note you would take would be case number SC 200826. You can look that up on public records information here in Iowa, Iowa Courts Online. And what I have is a motion for emergency stay of execution pending appeal. Comes now the defendants Keith Little and Joyce Schmidt, and respectfully moves this court for an order staying the execution of judgment for possession and writ of removal entered on. And like I said, they did not execute, grant a writ of execution because she wanted to take it under advisement. And so we'll be hearing back on that in about a week. So pending the final resolution of defendant's appeal. In support of this motion, defendant states the following: statutory grounds for stay. Defendant has filed a timely notice of appeal pursuant to Iowa Code 648.15 to preserve the status quo and prevent irreparable harm. The court has the inherent and statutory authority, and I would say duty as well, to stay execution of the judgment under Iowa's Rule of Civil Procedure 1.1006 and Iowa Rule of Appellate Procedure 6.601. Irreparable harm to disabled tenant, and this is in regards to my companion who has both physical disabilities and mental disabilities, namely dementia. Defendant is a person with a documented disability, specifically dementia and other physical disabilities, as defined by the Iowa Civil Rights Act, Iowa Code Section 216.2, subsection 5. Physical danger, eviction, and subsequent homelessness pose a clear and present danger to the defendant's life. Persons with dementia suffer from transfer trauma or relocation stress syndrome, where sudden displacement leads to a rapid cognitive decline, increased risks of falls, and elevated mortality rates. The medical necessity: defendant requires stable housing to manage life-sustaining medical care. Homelessness would deprive the defendant of the climate-controlled environment and sanitary conditions necessary to prevent exacerbation of her condition. Civil rights violations and procedural errors. Violation of fair housing laws. Under Iowa Code 216.8a, the Federal Fair Housing Act, and the Federal Fair Housing Act, the landlord had a duty to provide reasonable accommodations. Defendant contends the landlord failed to accommodate the defendant's disability regarding noise and other issues, and the current eviction is a direct result of that failure. Statutory breach of duty. The landlord is in material breach of Iowa Code 562A.15, maintenance, for failure to maintain a safe and habitable environment. The trial court committed a prejudicial error by awarding possession to a landlord with unclean hands, who is in active violation of health and safety statutes. So what we're saying here is, if that decision comes back in a week and they grant the writ of execution, they have made a procedural error. If they come back with a dismissal, then we move forward with our civil rights claim. Request to waive or set reasonable bond. In any kind of appeal, you're required to provide some kind of a bond in case the plaintiff would lose any kind of income because of it. But we are asking that that be waived. Defendant requests the court waive the supersedeas bond requirement or set it at a nominal amount, as the defendant is an indigent and a high bond would effectively deny the defendant's constitutional right to an appeal. Justice is not for sale, denial, or delay. Wherefore, defendant respectfully requests that this court immediately stay the execution of the writ of removal, allow the defendant to remain in the premises pending the outcome of the appeal, waive or set a nominal appeal bond in light of the defendant's disability and financial hardship, and of course, placed a date and sign. So that is the motion for emergency stay of execution pending the appeal. And then, of course, we have to timely file that appeal. So we have a notice of appeal and statement of errors, again, under small claims, S.C. 200826. Notice of appeal and statement of errors comes now the defendants, Keith Little and Joyce Schmidt, and hereby appeals the judgment for possession entered by the magistrate on such and such a date, if they grant that writ of execution, to the district court. So we're in small claims court now, and it's being administered by a magistrate. So we would appeal to a higher court, which in our case wouldn't necessarily be the state court, but the local district court. So it's to enter it into the district court, removing it from the small claims court. If you try to do this in the small claims court, you're limited to punitive damages, and Iowa has a maxed out of $6,500, and that means we would get $6,500 at the expense of the property management, but we wouldn't be allowed actual damages for emotional distress and stuff, which we're going to be asking for $25,000. Very, very reasonable amount in a civil rights claim. Statement of errors. The defendant asserts the magistrate committed the following prejudicial errors of law and fact: failure to apply mandatory statutory notice requirements. The magistrate erred by granting an eviction despite the plaintiff's failure to provide a 7-day notice to cure for a noise complaint as required by Iowa Code 562A.27, subsection 1. Strict compliance with notice is a jurisdictional prerequisite for a forcible entry and detainer action. And that is, the first duty in law is legal notice. We gave them our legal notice through a noise complaint, and by their statutory duty, they failed to give the upstairs tenant notice that they needed to quiet down, which allowed the situation to be to escalate. And now they're trying to evict us under a clear and present danger, when they're the ones that provided a clear and present danger to myself and my companion by not following that statutory requirement. Failure to recognize retaliatory conduct. The magistrate erred in failing to apply the presumption of retaliation. There is a presumption of retaliation if you're evicted within a certain time after you make a complaint to a landlord. In Iowa, it used to be 6 months. Now it's a year. This has been less than 1 month. So it's most certainly retaliatory presumption there. Evidence was presented that the defendant complained of life safety maintenance issues, specifically regarding a noise complaint, within 1 year of the filing. Abuse of discretion regarding disability protections. The magistrate failed to consider the defendant's right under the Iowa Civil Rights Act, section 216.8A or 0.8A, as I mentioned earlier, and the federal Fair Housing Act. The court ignored evidence that the landlord failed to provide reasonable accommodation through a 7-day notice to cure to the upstairs tenants for a person with dementia whose health was directly endangered by the landlord's maintenance failures. Error in clear and present danger, which is the statutory code that they're trying to use against us to evict us. The magistrate misapplied Iowa Code 562A.27A by failing to recognize the landlord maintained a hazardous environment, a chaotic environmental nuisance from the excessive noise upstairs that constituted a danger to the life of a disabled tenant. Request for de novo review on the record. Defendant requests that a district court judge review the record of the proceedings below and reverse the judgment of the magistrate. Prayer for relief. Wherefore, defendant respectfully requests that this court set aside the judgment of the magistrate, dismiss the petition for forcible entry and detainer, and award any other relief the defendant's request or that the court deems reasonable attached here too. And then, of course, dated and signed. And then we have the prayer for relief attachment. Wherefore, the complainant defendant respectfully requests that this court enter a judgment in their favor and against the respondent plaintiff for the following: permanent injunctive relief, enjoining the respondent from proceeding with the wrongful eviction and compelling the respondent to perform their statutory duties under Iowa Code 5628.27 and 5628.15, which would be the notice of cure to the upstairs tenants and then the eviction following. Actual damages in the amount of $25,000 for emotional distress, mental anguish, and the exacerbation of medical conditions, dementia, caused by respondents' failure to accommodate and wanton disregard for complainant's safety. Punitive damages in the amount to be determined by the court to punish the respondent's admitted intentional ignorance of the law and deter such future conduct in the amount of $6,500. Cost for costs of this action and any other relief the court deems equitable. And then we have the Iowa Civil Rights Complaint. Housing discrimination complaint, Keith Little and Joyce Schmidt. Respondent, MGT Property Management Company / Listy Wickham. Basis, disability, 2 knee surgeries, multiple foot surgeries, and what's known as frontal temporal dementia. If you guys are familiar with Bruce Willis, the famous movie actor, that's what he has. It's the same thing. And like I said, they go through various different emotional stresses, particularly in consideration to excessive noises, relocation. They're used to an environment, and if you relocate them even to another peaceful environment, they go through great amounts of stress. Trying to go out and look at places while we try to prepare to move, my companion gets very fidgety and emotionally scared and traumatized. It is very real. And I'm the one that has to put up with those consequences. I'm the only outlet she has. So again, when the landlord fails their strict statutory requirement, their duty to issue a 7-day notice to cure, that is the epitome of ignorance of the law is no excuse. And like I said, this lady's been doing property management for 8+ years, admitted that she did not give a 7-day notice to cure, and admitted that she was not aware of the strict statutory duty to do so. And again, ignorance of the law is no excuse. Thanks to Jack Talcott and all of his people rating me now. I appreciate it. May you all be blessed. Drop by to say hello and subscribe. Good night. God bless. Thanks, Trexty. Appreciate it. Yes, we appreciate the raid. We've got Kylan LX8OP says hello. Captain Action is here, one of my favorite guys. That we come to the end of this one. Again, go over to El Perro to see the full videos. Can I say, got more coming, and showing you again firsthand that it's systemic up and down the chain. The tenant upstairs didn't do what he did, or didn't do what he was supposed to. The landlord didn't do what they were supposed to. The court's not doing what they're supposed to. The clerk's not doing what they're supposed to. So we're going to find out. And in the future, as I keep posting these updates, you'll see how the timeline went and how we sent certified mailings, and some of them got rejected. At this point, just one so far, but we're addressing that now. And just keep an eye out, keep watching, and we'll see you again soon. Meantime, remember, I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me.